Imagine you are driving home from the range on a Tuesday evening. Your hands are at 10 and 2, cruise control is set, and you are doing everything right. But then you see those red and blue lights flash in your rearview mirror. Your stomach drops. Not because you have committed a crime, not because you are a criminal, but because sitting in your back seat is a large, black Pelican hard case. It is locked. It is legal. But to a police officer, that case is a mystery box that screams, "Investigate me." And that box is about to become the center of a constitutional battle that most people lose before they even realize it has started. What happens in the next 3 minutes will determine whether you go home to your family or go to jail on a technicality. My name is Sarah. I am a legal educator. And today we are going to break down exactly how to stop police from searching your gun case. We are going to look at the law, the psychology of the stop, and the specific words you need to know. But first, let me tell you about Elias. Elias is a law-abiding citizen. He works in IT, pays his taxes, and shoots competitive pistol matches on weekends. He's driving his SUV through a jurisdiction that is a little less gun-friendly than his hometown. He gets pulled over for a minor infraction, let's say a burnt-out license plate light. Officer Miller approaches the window. Officer Miller is a veteran cop, calm, authoritative, and trained to look for anything out of the ordinary. Elias rolls down the window. "Good evening, officer," Elias says, trying to keep his voice steady. "License and registration, please," Miller replies, shining his flashlight into the back seat. The beam of light hits the Pelican case. It is obvious what it is. It's not a violin case. It's not a suitcase. It's a gun case. Officer Miller pauses. "Heading to the range?" he asks casually. This is the first trap. Elias thinks this is friendly conversation. "Actually, just coming back," Elias says, trying to be helpful. "Any firearms in the vehicle?" Miller asks. "Yes, sir, in the case in the back." Now, depending on the state, Elias might have a duty to inform, so let's assume he did the right thing by disclosing. But here's where it goes wrong. Officer Miller nods. "Okay, for my safety and yours, I just want to check the serial numbers and make sure everything is unloaded and stored safely. You don't mind if I take a look, right?" Freeze frame. This is the moment 99% of people lose their rights. Elias knows he is legal. He knows the gun is unloaded. He thinks, if I say no, I look guilty. If I show him, I prove I am innocent, and we can leave. So Elias says the words that sink him. "Sure, officer, go ahead." Officer Miller opens the back door. He unlatches the case. He handles the firearm. Maybe he finds nothing. But maybe, just maybe, Elias forgot a loaded magazine in the same compartment as the gun, which violates a specific local transport law. Or maybe the officer decides to search the rest of the car now that he's inside. Because Elias consented, anything found is admissible in court. Elias thought he was helping. In reality, he waived his Fourth Amendment protection against unreasonable searches and seizures. Now, let's rewind. Let's see how this should have gone. But before we do, we need to understand the legal battlefield. The Fourth Amendment protects you from unreasonable searches. Generally, for police to search your vehicle, they need one of three things. 1, a warrant, very rare in traffic stops. 2, probable cause. 3, consent. Let's talk about probable cause versus reasonable suspicion. These are legal terms you must understand. Reasonable suspicion is a lower standard. It means the officer has a specific, articulable reason to believe a crime is happening or you are armed and dangerous. It allows them to stop you. It allows them to pat you down if they think you are armed. But generally, it does not allow them to tear your car apart. Probable cause is a higher bar. Probable cause means there is a fair probability that evidence of a crime will be found in the car. If an officer smells marijuana, that is probable cause. If a drug dog alerts on your door, that is probable cause. If they see a bag of white powder on the seat, that is the plain view doctrine. But here's the million-dollar question. Is a gun case in plain view considered probable cause? Generally, the answer is no. Owning a gun is legal in the United States. Transporting a gun is legal if done correctly. Therefore, seeing a gun case doesn't automatically mean a crime is being committed. It suggests lawful activity just as much as unlawful activity. Courts have held that the mere presence of a legal item cannot be the sole basis for probable cause. However, police will try to bypass this legal hurdle by getting you to give them the third key: consent. When Officer Miller asked, "You don't mind if I take a look, right?" he was asking Elias to waive his rights. He was asking permission because he likely knew he did not have the legal authority to search without it. Let's go back to the car. Elias is sitting there. Officer Miller asks, "You don't mind if I take a look, right?" This time, Elias is prepared. Elias keeps his hands on the steering wheel. He looks the officer in the eye. He stays calm. He does not get aggressive. He doesn't say, "I know my rights," in a snarky tone. He simply says, "Officer, I do not consent to any searches." Silence. The tension in the air spikes. Officer Miller stares at him. "What are you hiding, Elias? If you're legal, it shouldn't be a problem." This is the pressure test. This is where they try to coerce you. They might say, "I can just get a dog out here." They might say, "You're making this harder than it needs to be." Elias takes a breath. He repeats the phrase, "I understand, officer, but I do not consent to any searches." Now, Officer Miller has a decision to make. Does he have probable cause? If he does not, he cannot legally open that case. If he forces the case open anyway, and Elias clearly refused consent, any lawyer worth their salt can file a motion to suppress that evidence later. But if Elias said yes, the lawyer can do nothing, because consent cures the officer's lack of probable cause. Let's dig deeper into the plain view doctrine. The plain view doctrine allows police to seize evidence without a warrant if three conditions are met. 1, the officer is lawfully present at the place where the evidence can be viewed. 2, the officer has a lawful right of access to the object. 3, the incriminating character of the object is immediately apparent. This third point is critical for gun owners. Is a gun case immediately incriminating? No. Unlike a bag of heroin, a gun case is a container for a legal object. Unless the officer knows you are a convicted felon, or the gun case is transparent and shows an illegal sawed-off shotgun, the case itself is not contraband. Therefore, plain view allows them to see the case, but it does not grant them the right to open it. This is a crucial distinction. However, there is a dangerous exception you need to know about. It's called the Terry frisk of a vehicle, coming from the Supreme Court case Michigan versus Long. If the officer has reasonable suspicion that you are dangerous and might access a weapon, they can search the passenger compartment for weapons. Note the difference. They are searching for weapons to protect their safety, not searching for evidence of a crime. This is a nuanced legal area. If the case is locked and in the back seat, out of your reach, can they search it under Michigan versus Long? Arguments can be made that if you're detained outside the car, you can't reach it. But officers will argue that you will eventually be released back to the car, giving you access to the weapon. This is why keeping the case locked is so important. A locked case is a strong argument against immediate accessibility. If the officer says, "I need to check it for my safety," and you have the key and you refuse to open it, they might detain you longer, but you should never physically resist. Let me repeat that. Never physically resist. If the officer says, "I am searching this car whether you like it or not," you step back and say, "I do not consent," then you let them do it. You fight the battle in the courtroom, not on the roadside. Now, let's talk about the safe passage provision. The Firearm Owners Protection Act, or FOPA, is a federal law that protects you when traveling between two places where you can legally possess firearms. For example, driving from Vermont to Pennsylvania, passing through New York. Under FOPA, if the gun is unloaded and locked in a container not accessible from the passenger compartment, like the trunk, you are protected. However, and this is a massive however, police in states like New York and New Jersey often treat FOPA as an affirmative defense. That means they might arrest you anyway, confiscate your guns, and let you prove your innocence in court months later. So simply yelling FOPA at the side of the road is not a magic shield. This brings us back to the strategy of refusal. Why refuse a search if you are compliant with FOPA? Because you don't want to be the test case. You don't want the officer digging through your luggage to see if your magazines are compliant with local laws. You don't want to risk them finding a loose round of ammunition under the floor mat, which could be a felony in some jurisdictions. By refusing the search, you are closing the door on the investigation. You are forcing the officer to either let you go or break the law to search you. Most officers, when faced with a polite, firm refusal and no probable cause, will choose the path of least resistance, writing the ticket and leaving. So let's summarize the actionable steps you need to take. Step 1. Prevention. Don't have the gun case visible if you can avoid it. Cover it with a blanket. Put it in the trunk. Out of sight, out of mind. If they don't see it, they don't ask about it. Step 2. The setup. If you are pulled over, turn off the car. Turn on the interior light. Roll down the window. Place your hands on the steering wheel. This lowers the officer's tension immediately. A relaxed officer is less likely to fish for probable cause. Step 3. The question. If they ask, "Do you have weapons in the car?" Know your state law. Some states require immediate disclosure, others do not. If you must disclose, say, "Officer, for transparency, I have a firearm legally stored in a case in the back." Step 4. The trap. If they ask to search, check, or see the firearm, say, "Officer, I do not consent to any searches." If they ask why, say, "I rely on my legal counsel's advice not to consent to warrantless searches." Step 5. The persistence. They will push. They will say, "If you have nothing to hide, it's fine." You must be a broken record. "I understand, but I do not consent to any searches." Step 6. The outcome. If they search anyway, do not interfere. State clearly, "I am not resisting, but I am maintaining my objection to this search." Then remain silent. There is one more crucial thing to understand about constructive possession. If you are driving a car with passengers and there is a gun case in the back, if that case is unlocked, everyone in the car could theoretically be charged with possession of that gun if it turns out to be illegal or if one of the passengers is a felon. Locking the case protects you. It protects your passengers, and legally it creates a higher expectation of privacy than an unlocked bag or an open box. By locking it, you are signaling to the world and the law that this is private. Let's address the inventory search loophole. If the police arrest you for the traffic violation, which they can do for many minor offenses in some states, they will tow your car. Before towing, they are allowed to conduct an inventory search to catalog items in the vehicle. This is a valid exception to the warrant requirement. However, they cannot use an inventory search as a pretext for a criminal investigation. If they open a locked gun case during an inventory search, the legality gets very complicated and varies by state. But again, if you consented earlier, none of this matters. You gave up the game. Never give up the game. Finally, I want to talk about your attitude. Many people watch auditor videos online where people scream at cops. "I don't answer questions. Am I being detained?" While legally grounded, this aggression often escalates the situation on the roadside. Your goal is to be the gray man, boring, polite, forgettable, but unyielding on your rights. You can be respectful and still refuse a search. "I appreciate you doing your job, officer, but I cannot consent to a search." That is harder for them to fight than a screaming match. Remember, the Fourth Amendment is like a muscle. If you don't use it, you lose it. Every time a citizen consents to a baseless search, it reinforces the police practice of asking for one. Every time a citizen politely refuses, it reinforces the boundary that the Constitution set for us. So, check your local laws, know if you have a duty to inform, get a good lock for your case, and memorize that phrase. I do not consent to any searches. It might feel awkward in the moment, your heart will race, but it is the most powerful shield you have. Stay safe, stay legal, and keep educating yourself. If you found this breakdown helpful, consider sharing it with a friend who goes to the range. Most of them have no idea they are one question away from waiving their rights. I'll see you in the next one.